Hi, this is Chris McKaylee. In today's podcast, I wanted to talk about some court decisions that are related to the California legislative process. Now, as you can imagine, there are quite a few cases that relate to the legislative process in the state of California involving the legislature. And I've just pulled a few because they're generally well known and they deal with some distinct issues. The first one is Kaufman and Broad Communities versus Performance Plastering, a 2005 California appellate court decision, where the court did three things. First, they clarified that a determination of the existence of an ambiguity in a statute occurs not at the time of a motion for judicial notice, but by the panel of judges hearing the appeal. Second, the opinion lists what is deemed cognizable and non-cognizable legislative history for interpreting California statutes. And the third is to acknowledge the propriety of taking judicial notice of enrolled bill reports from a governor's file. The case lists sources of legislative history that are considered by state courts when they try to ascertain legislative intent. The court set forth the form by which it'll consider properly cognizable legislative history. And they said that a motion for judicial notice must be made with the understanding that the judicial panel ultimately adjudicating the case may determine that the subject statute is ambiguous. The court also said that the motion is required to identify each separate document for which judicial notice is being sought as a separate exhibit, and that points and authorities need to be submitted to cite authority for each exhibit that is being deemed cognizable legislative history. The next case of interest is People's Advocate versus the Superior Court of Sacramento, with the California Legislature as the real party of interest, a 1986 California appellate court decision. And here they said that the real parties in interest, the legislature, had moved for judgment on the pleadings, and they were challenging the provisions of a ballot measure that sought to regulate the internal rules of the legislature, as well as the selection of its officers and employees, the selection and powers of committees of the two houses of the legislature, and other efforts to limit the content of budget legislation. And the real parties in interest, the legislature, challenged these provisions as violating the state constitution and not being severable. What happened was that the court said what's at issue is not the authority to amend a statute, however adopted, but the power to say what content a future statute may have, and the authority to enact statutes which appropriate money for the support of state government is set forth in Article 4, Section 12 of the state constitution, and it provides for the appropriation of monies through the adoption of the budget bill, and provides for special appropriations measures that may be adopted outside the budget bill process, and basically said that as a statutory initiative, it violated the Constitution and the legislature's ability to regulate its own internal rules. The next case is French versus Senate, a Cal Supreme Court case dating back to 1905. And the court said that a house of the legislature has power to adopt any procedure and to change it at any time and without notice, and that the legislature cannot tie its own hands by establishing rules, which is a matter of power. It cannot at any time change and disregard. Its action in any given case is the only criterion by which to determine the rule of proceeding that's adopted for that case. The next decision is In re Colley, a 1952 California Supreme Court case. And here our High Court said that neither house of the legislature may bind its own hands or those of future legislatures by adopting rules that are not capable of change. They said, quote, "It's the general rule that one legislative body cannot limit or restrict its own power or that of subsequent legislatures, and that the act of one legislature does not bind its successors." The next case of interest is Howard Jarvis Taxpayers Association versus Bowen, a 2013 California appellate court decision. And here the Court of Appeals said, the narrow but potentially recurring and important question that we address in these writ proceedings is whether the California Constitution, as amended by the voters in 2010 by Prop 25, allowing the legislature to identify blank bills with an assigned number but no substance, a so-called spot bill, in the main budget bill and pass the budget and thereafter add content to the placeholder bills and approve them by a majority vote as urgency legislation. And what the court said was, we conclude that spot bills, which remain empty of content at the time the budget is passed, are not bills that can be identified within the meaning of Article 4, Section 12, Subdivision E2 of the state constitution, and enacted as urgency legislation by a mere majority vote. So as a result, the court confirmed that the legislature cannot add content to spot bills as a means of avoiding the 2/3 vote requirement for appropriations bills. The next case of interest is Marine Forest Society versus the California Coastal Commission, a 2005 California Supreme Court case. And here the High Court upheld the constitutionality of the California Coastal Commission under the separation of powers clause found in the California Constitution in Article 3, Section 3. And the court basically evaluated the structure of the commission using the standard whether these provisions viewed from a realistic and practical perspective operate to defeat or materially impair the executive branch's exercise of its constitutional function. And the court considered whether the statutes either improperly intrude upon a core zone of executive authority, impermissibly impeding the governor in the exercise of his or her executive authority or functions, or secondly, retain undue legislative control, compromising the ability of the legislative appointees to the Coastal Commission to perform their executive functions independently and without legislative coercion or interference. And here the court found that the structure of the commission did no such thing. It's permissible and valid under the state's separation of powers doctrine. And the last case is the California War Veterans for Justice versus Tom Hayden, a 1986 California appellate court decision, where the Court of Appeal held that jurisdiction over the legislator's qualifications as an assembly member belongs exclusively to the assembly. The court said under the California Constitution, as under the federal Constitution, as well as the law of most states, the legislature has sole jurisdiction to determine the qualifications of its members and the sole right to expel them from membership pursuant to Article 4, Section 5 of the California Constitution. The court went on to say that for over 100 years, the California Supreme Court has consistently held that under our state constitution, the courts have no jurisdiction to inquire into the qualifications of the members of the legislature.